Welcome and thank you for coming. I really appreciate you taking the time out of your day to join us on this webinar where we're going to be talking about really new and interesting stuff that's happening in corporate law generally, in cannabis corporate law. I'm Meital Manzuri. I am the managing partner for Manzuri Law. I started the firm 14 years ago, which is a very long time, especially in cannabis law. It's been a really exciting ride. I'm headquartered here in West Hollywood, and we work a lot in Los Angeles, but all throughout California. Alexis, who's my lovely co-host, is based out of San Francisco area. And we focus primarily on cannabis and hemp, but now we're also getting into the world of psychedelics, which is really exciting. Our law firm does a lot of regulatory compliance and licensing work. We've been doing that for a really long time. And we also do a lot of corporate and transactional work. And that's really interesting in the cannabis industry. And that's one of my favorite things to do is some of those purchase and sale agreements and watching how all this corporate compliance and the regulatory compliance and then all the rules changing all the time. That's really what makes my job exciting and interesting. And I'm also on the board for the International Cannabis Bar Association. I'm on the executive committee as the secretary, and it's an organization that we are really, really enthusiastic about. And I hope that if you're not a member already, that you'll join. And I think you can join even if you're not a lawyer, but definitely for those lawyers out there, continuing legal education is amazing. The group, the network, just connecting with over 800 lawyers throughout the globe, actually, who do work in this space is incredibly valuable. I've been a member for I don't know how long, maybe 5-6 years. Alexis is the co-chair of the student committee with Callie, who's also with our office. So we're really involved, and we'll hope that you'll get involved if you're not. That's the International Cannabis Bar Association. If you use the code Manzuri, you'll get a discount on your membership. They have CLI coming up in Chicago, or a party actually tomorrow night in San Francisco, if you want to go to that. So if you have any questions about INCBA, feel free to reach out to me or to Alexis. And we get to hear from her in a moment. I just want to quickly go over the topics that we're going to be covering today. I think, Alexis, can you do the slide? Thank you. So first Alexis will be going over the Corporate Transparency Act. This is a new interesting compliance requirement for companies, a lot of disclosures. And it's, she's really going to be breaking it down for you. It's not that complicated, so long as you just, kind of do what you need to do. For more complicated corporate structures or companies, it is a little more intensive. So we'll be going over that. And then operating agreements, best practices for LLCs, we're really going to be covering kind of the highlights of what's required in an operating agreement. It's really important to think about, even if you're not a lawyer, when you're going into business and let's say you're starting an LLC, what are the major things that you and your partners have to kind of talk about, even before you come talk to a lawyer? That's really important. And then, like I said, I'm really excited about, the M&A market in cannabis. And so I'll be talking about what we can expect in 2024, just overall sort of market trends and what we're seeing and, what can be expected in the next year. So with that, I will kick it over to Alexis, who's going to be getting us started on these new requirements for FinCen.
Hello, everyone. So let me start with this mouthful. We're going to talk about the U.S. Treasury Financial Crimes Enforcement Network Beneficial Ownership Information Reporting Requirements. Wow. This is a new requirement as of January 1st, 2024. This is under the Corporate Transparency Act, which was initially signed in 2021. With the goal of combating illicit activity by capturing ownership information for specific U.S. businesses who basically have operations or access to U.S. financial markets. Basically, what they're trying to combat with this is tax fraud, money laundering, and potential financing for terrorism. So with the Corporate Transparency Act, they now have a new requirement that U.S. domestic small businesses and foreign reporting companies who are registered to do business in the United States, you now must report individuals who maintain ownership and control to the U.S. Treasury, FinCen. So if you operate in cannabis, this sounds similar to the DCC regulations of ownership and control. So kind of familiar with that, it's basically a similar sort of variation of that. With that, the beneficial ownership information reporting rule requires an entity to disclose information about the entity itself, so the business, and then two categories of individuals, the beneficial owners and the company applicants. So the beneficial owner, this is an individual who owns or controls at least 25% of a company or who has substantial control over the company. So again, if you operate in cannabis, this is similar to the owner requirements under the DCC, who set their 20% ownership requirements and the substantial control aspect as well. Company applicant is an individual who basically files for the articles of incorporation or sort of associated documents with the Secretary of State or the person who directs that person to file for those. Yeah, we'll talk about a little bit that more later. So how and when to file for these reports? These are filed online and in a phased approach. This is sort of the web page of what it looks like. And depending on when the entity was created, there's a phased approach. There's 3 different phases, 365 days. So you basically have a year, 90 days or 30 days. So the 365-day requirement, this is basically if your entity, so LLC, corporation, was created or registered prior to January 2024, you have a 365-day compliance window. So you have a year to get your ducks in a row, essentially. So if your entity is created in 2024, January 1st to December 31st, you have 90 days after your company's documents become filed or effective with the Secretary of State to file this initial report. And then FinCen, as of 2025, basically expects you to know what's going on and to be compliant with this anytime a new entity is formed, or as we'll discuss later, any changes need to be filed. So again, 2 reporting requirements, beneficial owners and company applicants. Who qualifies as a beneficial owner? A beneficial owner is, again, someone who exercises substantial control or owns 25% of the reporting company. Substantial control is defined as when an individual meets any of these 4 criteria. So a senior officer, someone who can fire and hire directors and senior officers, someone who makes important decision-making based on finances, structure, so important decisions, and anyone else who has some sort of substantial control. As you can see, this definition, you can have multiple beneficial owners, and you very likely will, depending on, like Meital said, the complexity of your organizational chart, your structure, how many owners you have, if they're LLCs, and you have to sort of assess who meets these requirements. And something that's sort of interesting is when you're filing for the beneficial owner, you don't have to differentiate between who has substantial control and who's actually an equity owner. It's just sort of an overarching. And then the 25% threshold ownership interest. This can be any kind of form of equity, stock, voting rights, any kind of capital interest, convertible instruments, options, anything that basically is a mechanism to establish ownership of the entity. So it's really crucial to assess who has substantial control, assess indirect and direct ownership interest of all of the owners in the entity who may meet that 25% threshold. So again, if your company's a little more complex, this might take some sussing out. And then you have to assess who has voting power and who has privileges and the access to control the entity. These all have to be reported. So who qualifies as a company applicant? Okay, as you remember, 2 categories of individuals, beneficial owners, company applicants. The company applicant reporting requirement is actually only applicable to entities that are formed post January 1st, 2024. So there's no retroactive action that is going to be required here, which is kind of great. And on the filing, if this does not apply to your entity, you simply check a box and all of the rest of the entries go gray. And so there's no requirement to report any of this. So if it's a new company post January 1st, 2024, this will be a new requirement that you will have to report. And again, the company applicant is basically the individual who files for the creation of the entity. You have to report at least one and at most two of these. The company applicant number two would be, again, the person who is primarily responsible for directing and controlling that. For instance, company applicant number one would be an attorney or a paralegal or perhaps an accountant, maybe a spouse. And company applicant, or it can be the owner, like the actual owner of the entity. And if applicable, and there is a company applicant number two, for instance, it would be the owner. So number one would be the attorney. I'd have to report myself. And then company applicant number two would be the business owner who told me to file for that. What specific information does my company need to include? Pretty basic: full name, trade name, doing business as name, complete US address, state, tribal, or foreign jurisdiction of formations. You'll have to basically say it was formed in California. And you have to provide the FEIN number. And for each beneficial owner and the company applicants, if applicable, you have to suss it down to an actual individual. So their full name, date of birth, current address. But this is an important differentiation, is that beneficial owners must report their residential street address. And company applicants, people who filed for the formation docs, they can report the business street address. And then you have to upload a picture along with the identifying numbers. So the numbers in the state or wherever you got this from, an image of your passport or a driver's license to FinCen, the portal. Yeah. How and when to report any changes or inaccuracies to reported information. Okay, so you file it, you realize you may have made a mistake or there's some changes. You have 30 days from when you find out about this inaccuracy or change to report and file for an updated BOI report with FinCen. So changes, this could be if a beneficial owner changes their address, if they move, if they change their name due to marriage or divorce, you'd need to file for a new BOI report. If their driver's license expires and they have a new driver's license, they would likely need to file a new report. It's simple, but something as significant as a contact information and a driver's license, they want it. They want to be able to track you down. You are not required to report changes to information about the applicant. So again, if the person who filed the initial articles of incorporation and the document for your entity, if they change their address, you don't have to go back in and update your FinCen reports. And again, if a company terminates or dissolves, you also don't have to go in and report that to FinCen. Any reported inaccuracies, so changes or inaccuracies, again, you have 30 days to update your report. But the Corporate Transparency Act, to be more specific, creates basically a 90-day safe harbor window before penalties are to be assessed. So get it done in 30 days if you can. 90 days is before you face penalties. So if I fail, what happens if I fail to file a BOI report for my company? There are penalties, civil and criminal penalties. The willful failure to report complete and accurate beneficial ownership information to FinCen may result in civil or criminal penalties. Civil penalties of up to $500 a day, which really can add up, or criminal penalties, imprisonment for up to 2 years and/or a fine of $10,000. So they sort of really get specific in that individual owners cannot basically be a stick in the mud. You cannot willfully provide incomplete or incorrect information to your company who's then going to report it to FinCen. And if you qualify as an owner and you refuse to provide information, you can personally be held liable. So yeah, it's important, and it's not something to avoid or ignore or be willfully fail to report. So that's FinCen. It's as complex as your corporate structure is, to be honest. So yeah. And now we're going to talk about operating agreements, sort of best practices, and sort of a segue to that. So there are many different reasons that an operator would choose to open an LLC over an S Corp. Some of those would be the number of members. LLCs can have an unlimited number of members. Corporations are maxed out at 100. There's ownership flexibility. S Corps can't be owned by other corporations. LLCs are partnerships. That's not the case with LLCs. But one of the most sort of advantageous aspects of using an LLC is that the governance of LLCs is a matter of contract law in contrast to corporations, which is largely defined by statute and case law. So as a result of that flexibility, LLCs and their operating agreements allow for flexibility in allocating profits, losses, and ownership percentages in ways that corporations are sort of restricted. So an LLC's operating agreement, it's crucial to clearly spell out every aspect of governance and management, control, economics, distributions, all of those. So the mechanics of an operating agreement. California requires LLCs to have an operating agreement, as does Delaware, New York, Missouri, and Maine. However, in California, an operating agreement can be oral, written, or implied. So it doesn't have to be written down. However, if you ever get to litigation, a court will often look to the specific words that are in the OA in order to determine whether there was proper consideration, money transferred, and if there's protections in that governing document. So although it's not required to be written down, best to do so. Also, it's a lot easier to pierce the corporate veil and make individual owners personally liable for liabilities of the entity if there isn't an operating agreement in place and if you're not abiding by said operating agreement. Courts really believe that LLCs should be run like a real business. Sometimes operators start them, form them, and don't run them as such. So it's an important aspect to consider, the same ideas of the duty of loyalty and fiduciary like safety nets that exist in basic principles of corporate governance in corporations don't apply in LLCs. It's important to have robust and sort of clear operating agreements to distinguish the stuff. So member managed or manager managed, that's the first sort of decision that you want to decide. If you don't have an operating agreement, the default rules are it's going to be a member managed LLC where every member who's a member of the LLC can unilaterally bind the LLC, which is it's fine if you're a one member LLC or two, but it can get complicated, obviously, if you don't delineate this in the OA. So member managed is pretty explicit. That's what it means. Everybody manages. And manager manages indicates that the LLC is managed by one or more managers. These can be members, but they can also be outside individuals. Okay, so basics to include in operating agreements. Again, it's all contract law. Would encourage you to, like Meital said, some of this stuff should be thought about with your business partners, even before you come to an attorney, just because these will become sticking points if you haven't discussed them. So sections to always include and think about are membership ownership percentages, voting rights, who gets to make decisions, what makes up a majority, the power and the duties of the manager members, who's supposed to be doing what, how, and who is going to choose the management team. Distribution of profits and losses. Does this align with the initial investments or is this in consideration of ongoing investments? Admission of new members. What is their required contribution going to have to be? Are they even going to admit new members? Meeting requirements. You want to think about where will they be held? How often? Buyout and buy-sell rights. So like right of first refusal kind of things. And disassociation triggers. What would result in the end of that entity? So just a couple, this is again pretty high level, but things to consider. The allocation of profits and losses. So the default rule, again, if you don't have an OA, an operating agreement. The default rule is to allocate profits and losses equally amongst all members. Of course, irrespective of their initial contribution, if this is where sort of, let's say, side agreements, but, agreements that talk to each other as well, not, but this can allow for parties to have this relationship play out very differently. Ownership, one member, one vote. Some states have a default rule that grants one member to each, or one vote to each member, irrespective of their capital contributions to the entity. So 70% contributor, this is an example, will have the same voting powers as a 10% owner. Obviously, that would be controversial unless this is distinguished in the OA. So important to get your contracts in a row. Tiebreakers. This is super important to consider. We often encounter people who started companies that are friends or business partners from past businesses, and they're like, oh, everything will be great. But you really want to consider when things are not great and how you're going to handle them and how important decisions will need to be made and who's going to make them, so you don't get to this place where you can't make decisions. So oftentimes tiebreakers can be solved in the form of a professional advisor, sometimes an outside attorney, a mediator, an arbitrator. Again, in the operating agreement, this can be a section that's delineated as to how this kind of plays out. In cannabis, we've also seen sometimes an outside party who has a complex understanding of the industry. That can also be a tiebreaker. And a rotating vote. This is kind of a novel. I did some research on it. This is also a way to consider operating things. You can allow members to hold alternating tie-breaking vote authority when there is a deadlock regarding a major decision. Not sure I've actually seen that in practice, but it's a proposition. And decision-making. Member managed and manager managed LLCs are prohibited from taking action outside of the ordinary course of business without obtaining the consent of all members. That's a default rule. So this would basically allow any member to object to any decision that a manager might make, and that would not allow for business to move forward and sort of happen. So yeah, it's important to, again, delineate these responsibilities and to who's going to do them.
Yeah, I mean, I echo everything that Alexis said. That's really good information. All that, information about the FinCen filing, it is something that, everyone's going to have to do. And if you're a lawyer or a representative and you're filing articles, you're going to have to start registering after 2024. So really interesting new change. And, the operating agreement basics are good to keep in mind for everybody who's like about to make a deal. Like if you're gonna do any kind of venture with somebody else, it's really important to really have those clear and transparent conversations early on, what the expectations are. And now with, several years of cannabis in California, we have seen a lot of different ways that these can go wrong. And so it's really important to be as specific as possible, and then also to update them, right? So like sometimes people start a company like, an operating agreement that was written in 2017, and now, here we are, and it's just out of date. And it's kind of like, I went to the dentist today and I had to get my x-rays. You have to service the entity every once in a while. It's really getting important stuff. And from here, I think it's really interesting to talk about, what we can expect in the next year, just from like a macro level, from a business industry level. We've seen a lot of smaller and medium-sized companies go through a lot over the past few years. So I thought it would be fun to just kind of do a very high-level review of, since legalization in 2017, what we've seen in the market as far as like trends and business trends. And obviously the hot topic for everyone right now is rescheduling. So, you would need hours and hours and hours to pontificate about like what that all means. But quickly, we'll just be talking about from a business perspective, what it could mean if and when it happens. In cannabis, we're always speculating. So it's natural that everybody's speculating about what's going to happen with rescheduling. And then just talking about the health of California cannabis businesses in general in this market, we're hearing a lot of different things. And so I'll kind of give you my opinion on that, and also on M&A trends. So I also wanted to make a note that if there are any questions, feel free to put them in the chat, and we'll address them as we go throughout or at the end if we missed it. So, I like to call 2017 to 2021 kind of the green rush here in California. That's when really we didn't know, what was going to happen early days. And so I think, in those first 4 years of legalization is when we saw this full green rush come in. We saw immense growth as the market, was highly, anticipated, and everyone was really, really excited about it. And the between 2017 and 2023, the pendulum swung from immense profitability and almost to threatened extinction for a lot of businesses, and actual extinction in the California market. And I think that's really interesting to review because it's kind of a predictor of nascent markets as they come online now. Overall, cannabis business valuations in California and other states tend to increase year over year substantially in the beginning, and then peak, and then kind of start to come down. We've seen that in California. We've seen that in other states. In California, we saw immense growth as everyone was really excited, and then we saw, that was starting 2017, 2018, and then it kind of hit its peak in or around 2021. In 2022 and 2023, we experienced a market-wide contraction. Valuations on the business, the industry, the licenses in California really started to come down. You had, a retail license, before 2020 is worth anywhere from like $5 to $20 million or more, depending on who's calling it. And now, we're seeing a contraction. We're seeing those valuations much, much lower, fraction of that, essentially. Licenses have become more available statewide. There's still a shortage of retail and still new people looking to come in. But when people come in and say, I want to start a new cannabis business, I have no experience in cannabis, I've never worked in it, I'm always a little bit wary. I don't want to, crush anyone's dreams or put out their fire. But, we are kind of on at least in California, we're done with the green rush phase of things. And so, you're really getting into a business that is not going to make you rich just because it's cannabis. You've got to come up with, a really sophisticated business or business model or something that consumers will love and be well capitalized, be ready to, reach the market in order to have success. So the conversations that I used to have with potential new clients in 2017, 2018, 2020, 2021, even, those started to change in 2022 and 2023. In 2022, we also saw, more saturation, like I talked about, a difficulty in competing with the illicit market. And then obviously, really the rubber meets the road when it comes to, profit crushing taxes and regulations. The businesses in California, especially retail, with, the compound taxation and everything they have to go through, and regulatory requirements, it's really, really difficult for them to make as much of a profit as they used to. And that's why, we're really seeing this squeeze. 2023, the squeeze continued, and we even saw, the 2023 devastated household brands like MedMen recently, and Herbal, and many others. That was a real eye-opening kind of year. I think we saw receiverships, which is a legal proceeding where, a business is put in custody of like an appointee who's going to either divide up the assets or, satisfy the vendors or the creditors. And that was something we hadn't seen before, and it's kind of become commonplace now. And so that, I would say, was kind of an ultimate low in cannabis. Flipping to the sort of positive side and the optimistic side. 2024, we see stabilization with rescheduling promises. So what I mean there is we're seeing overall stabilized market a tiny bit. We're seeing businesses who have been able to survive leaning out and figuring out how to run their business. And And then with rescheduling on the horizon, I think there's more hope than there's been in the last couple of years. So yeah, just going back in the early days of the green rush, private equity was available and investors were enthusiastic about the industry. Towards the end of the green rush, debt deals became preferred over equity by investors, but many were still able to secure private investment. And then in 2022, when we're talking about this real tight squeeze, debt was slowly was available still, but its availability was slowing. And, like in the herbal case, what we saw was essentially the credit line was called. And what that said to me was like, okay, the sort of viability of the market is really coming into question. And lenders are going to be a lot more scrutinizing and concerned than we've seen in the past. I don't know if that holds true because we still see these companies raising funds, but I think it's slowing down. So with that, as I said, 2024 is stabilizing, and one thing that's exciting on the horizon is rescheduling. This was a historical moment in the United States where the HHS recommended that we reclassify Schedule 3 to reschedule cannabis to Schedule 3 rather than Schedule 1. And, I've been in this industry, like I said, I started the firm 14 years ago. Before that, I did a lot of work in criminal defense. I did a lot of federal work, and I was involved in some cases where we were petitioning the court to do this. And, I think even as a law student, I was involved in something like that. And I remember that was 15 years ago, and thinking then like, oh, this is going to happen. The court is going to grant our motion to reschedule cannabis. And now here we are 15 years later, and it still hasn't happened, but a lot of other exciting stuff has happened. And, it's greatly anticipated. We've been told it's going to happen this year. There's a political push for it to a certain extent. For most of us in the industry, we're really, really scared to get excited about this because we've been let down so many times before. But the fact that this is an agency matter and it's really just the DEA kind of dragging their feet on this process, hoping that they'll win, if we get a different president in, maybe that'll help save them. We'll see. But that's what's really exciting. And really the most sort of relevant impact of rescheduling for us today is the fact that tax code section 280E prohibits deducting ordinary costs of business, especially for retailers. And if it was on the schedule as a Schedule 3, then there wouldn't be 280E issues. And for retailers, that is a huge deal because you're talking now about, these businesses that can't even write off rent in some cases, and this being available to them. So I'm excited about this. I think this would be a win for us if it went through. I've got this study on here where it shows that cannabis companies paid 1.8 billion in federal taxes in 2022 compared to non-cannabis businesses, and it's forecasted to be 2.1 billion in 2023. So that's significant funds that cannabis businesses are overpaying. And, I think for the market in general, it means improved financial health, especially in saturated markets like California. And also, the discussion about interstate commerce that we're seeing more and more, I think, and the advancement of psychedelics in the federal realm, it's all starting to build momentum. I think that the actual impact of rescheduling is going to differ on businesses to a certain extent on the size of the business. So the larger operators that we've heard about, like a Stizzy, or that's kind of the one that's probably the biggest right now since MedMen kind of just fell out. Some of the bigger companies, I don't think they're really gonna use any tax relief for M&A purposes. A lot of those companies have borrowed a lot of money, and they're really just still working on kind of cleaning up their books and improving their bottom line so that they can show the lenders that they're running a profitable business and secure more debt or defer debt. So I don't really see much M&A from the larger operators. I think that what we've been seeing, at least I could say anecdotally and also just theoretically, I think it makes sense, is that smaller and middle-sized companies, now that they've stabilized, if they've survived the industry, they've spent the last year or two really, being focused on costs and cash flow. And, it used to be like when we were talking about the IPO days in Canada, the biggest goal was to just get your top line revenue as high as possible. All you wanted was the biggest number coming in to show revenue. And now we're seeing that the bottom line is being more focused on. And so I think these companies, they could use rescheduling, tax relief, or just their improved overall financial health to start to grow and acquire other smaller assets to build themselves up. In 2023, we saw, very slow on, license acquisitions, license sales. I think we've started to see that pick up in the last few months. I think that comparing 2019, 2020, or even 2021, there, because the valuations almost had a 50% drop, there really were no buyers out there. And now that's changing. The market, the pendulum's starting to swing back a little bit. So I think that's going to be interesting. We're starting to get pick up, like I said, from those smaller and medium-sized operators who are now looking to kind of grow a little bit now that they've improved their financial health. Yeah, it's really just being in this industry. It's so volatile, and there's so many different things that we've seen come into play, whether it's local rules, politics, ever-changing regulations, social equity, really the ability to practically comply with the regulations has been really difficult, and in order to grow in the last few years. But like I said, with rescheduling and improved financial health, I think we have a sunnier outlook on the market. And I know I kind of sped through that. We saved some time for Q&A if anybody has any questions about what we've covered today, or cannabis corporate business operation in general. Feel free to ask, because I think that's the end of our presentation here. Was I talking really fast? Let's see who's in the audience here. See some familiar names.
We had a couple questions. When is the BOI due? Like I mentioned, there's a 3-phased approach, 365 days. So if your entity was formed before January 1st, 2024, you have to comply with this by January 1st, 2025. If your entity was formed in the year 2024, you have 90 days from formation, effective formation with the Secretary of State to file. And then starting January 1st, 2025, you have 30 days from effective date to file. There's another one. What are you seeing banks, credit unions, and financial institutions do in the market? Meital, you want to take that one?
Sure, yeah. There's been, I can certainly, comparing now to several years ago, there are more options. Obviously, it's not widely available. So you have to find an institution that's willing to go through all of the hurdles for, I think it's 1125, to show that you're licensed, to do all of that extra reporting from the bank side. We've seen some credit unions. There's obviously Salal in Oregon. I think they're based out of Washington, who does banking with cannabis businesses. But there's a lot of credit unions, local banks. So we're seeing it increase, but it is still difficult. We're seeing a lot of bank accounts still getting closed down or shut down. And, obviously, if safer banking comes through, then that's what we've all been hoping for. But I don't think it's going to happen this year, unfortunately. So we're all just kind of still trying to find that like friendly bank and that friendly banker. I can't think of, yeah. Salal is really the one that's, and Dama Financial. Yeah, I think they all take some good fees in there for the extra compliance work. And credit unions, I've seen increasing credit unions.
Kind of in a related vein, there's another question. Do institutional investors prefer investing in a corporation or an LLC?
I would say it depends. Famous lawyer answer. It
I was
depends.
thinking that. sense.
It depends on what your sort of like business plan and structure is. Overall, I think that the smaller of group of investors that there are, the more willing to be in an LLC. But if you've got kind of this bigger structure where you're going to be getting all these different investors or maybe really large, investments, they might prefer a corporation. So it really just depends. And a lot of times you're going to do kind of a multi-leveled structure. So you could have, the LLC be what we call the plant touching entity, the company that is actually participating in the cannabis business. And then you might have, a parent company or a subsidiary that's a corporation. That's where all the investors, have their shares. And then, the LLC would be wholly owned by the corporation. So that's a structure that we've seen quite a bit. So it can be kind of like a mixed bag. There is no kind of one way to do it. Corporations, C corps can be more attractive to investors overall, but it really depends on who those investors are. Is it friends and family? Is it, you're doing a seed round, you're raising a lot of money and that kind of stuff. So we see a lot of really complicated corporate structures in cannabis. I know because there is some distance that is desirable from the plant touching entity by the investors. So they want sort of like a buffer, or if you're going to own the real estate as well, you're going to want that probably in another company, not the plant touching company. So these plant touching companies often act like these kind of like silos to just own the license, and then the actual owners are on top of that.
Okay, then we have at what stage of the licensing process do I need an operating agreement? Can I wait until I'm operational? Wow, no, you cannot wait until you're operational. I mean, forming an entity requires filing the articles of incorporation or organization, but it also requires some document production, or document creation rather. So associated documents, you need to file for an FEIN, you need to have an operating agreement or have it just in your head and see how that works out. But yeah,
Well,
no,
not just let's say you're a solo, you're one person, oh, I just want to operate a license on my own. Even then, you could apply for the license individually, but then once you want to get investors or anything like that, that license is a challenge to transfer to a company. So it's really like that, it's not that expensive to get a company established, get the operating agreement done and make sure that you're clear. And then if you are looking for partners or investors, you're going to look a lot more put together on the due diligence side if you've got that corporate paperwork together. So yes, I agree with Alexis. You don't want to get operational and then do your operating agreement.
So we have a couple of sort of licensing questions, which we can certainly address. Are there any updates regarding the LA County Cannabis Program launch? I don't believe so.
Yeah, so with the LA County Bar Association, we have a meeting next week, and the county usually comes to those meetings, and they're still developing their program. I don't know about like a launch date, but I think they were planning to launch this year.
Okay, another one. Oh, Jim mentioned that First Citizens is open to hemp businesses for pinking. So good to know.
Hemp business, that's right.
Yeah. And then he also asked, how are hemp-focused businessing is being regulated versus cannabis, especially with hemp-derived Delta-9 being integrated into beverages and sold into mainstream retailers? Wow, there's a lot in there.
What was the question?
So how are hemp-focused businesses being regulated versus cannabis? And then he asked about hemp-derived Delta-9 being integrated into beverages. Well, the Farm Bill is up for renegotiation. It was supposed to be signed in 2023. It's every 5 years. They are considering there's no proposals for it to come out in 2024. It should have come out sometime like a draft in March. There's no draft. So as long as they can keep passing these sort of funding bills, they don't have to come up with another farm bill. So there are people in the industry that believe that the next one's going to be in 2025. And by that point, the federal government will have come to the realization with what they did in 2018, with the legalizing of all these other alphabetical cannabinoids, THCA, THCV, Delta 8, Delta 10, all of Delta 9 derived from hemp, all of those. Basically, different state, because although it is federally legal, hemp is federally legal, 0.3% or less of Delta 9 THC, that's federally legal to cross state lines. Each state is sort of catching on to these intoxicating hemp elements. So hemp-derived Delta 9 now being in beverages, right? Minnesota was one of the states that like it was sort of a free-for-all. Well, there's a bill being passed right now, and it's got through the House, that they're going to put an age requirement on this. They're going to sort of rein it back in a way, because all of these products are out on the marketplace, unregulated by the FDA, and some are largely unregulated by their states. So California currently has a bill that has been proposed in order to integrate the hemp businesses and all of these intoxicating hemp programs into the cannabis industry, because it's sort of created this parallel universe for hemp, and they can have these intoxicating products on the market directly competing with cannabis and all of their high licensing and regulations. So it seems like it's an open market, and it is, but I would argue that state legislators are catching on, are prohibiting it, are banning it, regulating it in some way, or trying to combine it with the already legal cannabis systems that may exist in that state. Long-winded answer.
It's
But
like when we wrote the legal weed book, like the first version of it, like in 2017, one of the chapters was hemp, the great conundrum, or the great hemp conundrum. And it's like we're still there. We're still in the great hemp conundrum. And now we're still trying to figure it all out. And it's just kind of the reverse of cannabis in the sense that it was federally legal, and then the states are the ones that are now enforcing, versus cannabis being federally illegal and states being the ones that were not going to enforce on it. I think overall, everybody just wants transparency, some regulatory commitment. And when the Farm Bill was passed, there was this sort of like fallacy created where we created two different definitions of cannabis, for cannabis and hemp, and they're the same plant, identical. So really, we're never going to get to sort of like homogeneity or like, understanding until we have just, combine the two plants, which is what California has done to a certain extent in this new bill that Alexis was referencing, and trying to attack it by qualifying what's a intoxicating cannabinoid versus not, and having some sort of subjective element there, which is going to be hard to enforce. So, every kind of like 3 months, we have a flavor of the month cannabinoid. Right now, it's THCA is having a big moment. And that one's really tricky to analyze. But I think it's a really good question, like what is going to happen between the two markets? And I'm hoping that at some point it'll just converge into kind of like one system where everybody is not subjected to strenuous regulations. So cannabis, maybe they could lighten it up a little bit. Hemp, they could kind of like strengthen it a little bit. But like Alexa said, the Farm Bill wasn't signed last year. I've heard from experts that they're skeptical of it getting signed this year. I think that the motivation for signing it might be some of this like enforcement issue, and kind of clarifying what to do with these extra cannabinoids that are actually psychoactive, or, have those impacts, but they're not technically illegal.
I mean, some argue that the federal government already legalized cannabis with the 2018 Farm Bill, so they just don't know it, or now they know it. But, yeah.
Yeah.
Let's see what else. There's what is all this buzz about Delta strains that I'm seeing at head shops? Is this legal? Again, if this is derived from hemp and then synthetically replicated into a product, it may be legal. It may be in a gray area. It's kind of depends on what it is and the concentration. Different states are putting limits on like per package of the percentage compared to Delta 9 THC. It's sort of complicated.
In California, the one bright line rule we have is that you can't have any inhalables at a smoke shop. So any smoke shop that has a vape or smokable flower, that's the one no that the CDTFA is cracking down on, CDPH. So that's one no. And then the other stuff that you're seeing, in California, we don't see it as much because we have cannabis, but in states where they don't have cannabis, it's everywhere. I mean, legal cannabis, I should say.
Yeah. We got a question. Are you seeing anything innovative in the industry?
I
Other
think
than
that,
all different ones,
what's that?
I said, other than people trying to assess the viability of these alternative cannabinoids and how they can use them, that's innovative in the last year, but you probably know better than I.
I think that people in this space are naturally innovative. Everybody's an entrepreneur, and there's always new stuff that we're seeing. Like, not to keep going back in history, but I remember like when people would call me, be like, I want to develop, and the first time I heard the word tincture, I was like, excuse me, what do you want to do? And it sounded like so out of this world at that time. So, and since then, always everybody in this space is innovative. I don't know that there's like one product or one thing. I think that, one thing we're seeing more of is just people getting more creative about being able to operate in other states. So not being so limited to one state, licensing out their IP to an operator in another state just to get their brand and their name out there. I don't know if that's innovative, but I think that's like the spread that we're seeing happen more frequently. Yeah, I think that really the innovation award goes to psychedelics, I would say, right now. That's kind of, I think, more, the psychedelic is having this real renaissance. And they've got the research, from the 50s and the 60s and before that cannabis never really had. So I think we're going to see a lot of innovation there as a brand new market.
Dope. Maybe just one more question. It seems like the beneficial ownership information reporting requirement is a federal requirement and cannabis is federally illegal. Will a BOI submission create any risks of prosecution for companies engaging in commercial cannabis? So there is no element of the reporting requirement that requires you to identify what kind of business you are. So this is just around the entity itself. Like we said earlier, sometimes corporate structures will create sort of barriers between the plant touching company and the actual non-plant touching companies. But all of these will require submissions. I don't know really how to answer this. Like, is it going to create any risks?
I mean,
No.
we used to confront this question when it comes to like, should I even get my EIN or should I get, do any of this sort of like government reporting because it's federally illegal? And, I think that the toothpaste is out of the tube when it comes to state legal operations. So long as you are not operating outside of the law, there shouldn't be an issue or like some sort of threat of federal enforcement. It's increased transparency, it's increased disclosure. But if you're in a state legal market, I don't think that it's going to bring like a bigger spotlight to you or, bring any further issues. So by way of just the FinCen reporting, I don't think that you're putting yourself at risk. It's going to be, whether there are any activities that are questionable, that's going to, maybe spur that.
Yeah. Okay. Well,
Yeah, I think that's it for today. Thank you all for joining. I hope you found it helpful. This will be available, the recording online soon. And I'm Meital Manzuri, and this is Alexis Lazzeri. If you have any corporate cannabis legal needs or licensing needs, hemp, psychedelics, we're here. Give us a call, set up a consultation, and hopefully we'll have another webinar here for you soon. Sign up for the International Cannabis Bar Association if you're not already a member. Use the code Manzuri to get a 15% discount and, and hope to see you soon.
yay.